Good afternoon. Hello, hi, and welcome to the DPS Renters' Rights Act Settle into New Legislation webinar. Myself, David Hackett, Head of Client Management here at the DPS, and Susie Crolla from the Guild of Letting and Management. How are you doing, Susie? You okay?
Yeah, really good, David. Nice to see you.
Lovely to see you again, as always. We're here, the final in the series of webinars we've done. The Renters' Rights Act is live, of course, since the 1st of May. How have things been from your side? I'm sure you've been very busy leading up to the 1st of May. Were most people sort of ready for it? Did they need further support? How did it all go?
Yeah, I think that obviously the people that we worked with over the last 2 years were definitely ready. I think there were some people, namely landlords, who were caught by surprise, which sounds a bit odd, but it's true. But yes, I think in the main, people were very organised, definitely.
Got it. I think that's all down to the great webinars you've done for us already. That's what I think, Susie, if I'm being honest.
Thank you.
Well, we spoke about those webinars we've done already. They were broken down into various sections. So anybody joining today, if you didn't get a chance to watch those sessions, they can be watched on demand and live. So share them with your colleagues, friends, family alike. And likewise, today's session will, of course, is a live one. It will be ready for recording for anybody to watch back at their leisure. So from our perspective, this is a live session. We got some great questions in from people ahead of this. So we'll have a Q&A at the end. But the main body of the session, of course, will be with you, Susie. So I shall pass over and leave you to it.
Thank you, David. Well, good afternoon, everyone. As David said, what we're doing today is looking at, as the title suggests, settling in to new legislation. And it's only actually been almost 6 weeks. It seems actually longer than that. So I'm going to do my best to lead you through what I'm referring to as the new norm. Now, it's not just the implementation of phase 1 that we're going to be thinking about. It's the impact on landlords, letting agents, if there are any letting agents online, and also tenants. It's important to understand that this legislation, as with all legislation, but this one in particular, is two sides of the same coin, and it impacts landlords and letting agents as well. There is one thing that I just want you to be aware of, and you know, it's a little bit of an icebreaker, and that's that there are some polls within the presentation this afternoon. So look out for those and see how familiar you are with the Renters' Rights Act. So I want to cover off 2 new legal duties, which we discussed in one of the sessions that we delivered with DPS. And this relates to the written statement of terms and information sheet, written statement for short, which imposes new legal duties on the landlords. And this written statement, and you could think about this as one document, or you could think about this as a separate document that you serve alongside the assured periodic tenancy, only applies to new tenancies that have been created and will be created from the 1st of May 2026 and onwards. So what is this written statement? And it's just clarifying probably what you already know. I actually feel really comfortable about this, both personally, professionally, and legally, in the sense that what this does, this written statement, is provide the tenant with the core terms of the tenancy. Now, what we've done as an organisation is to include the written statement alongside the periodic tenancy. So effectively, the two things are combined. And this gives the tenant an idea, as I said, what the key terms of the tenancy are. So that's really, really important to be aware of. These terms are something that you are very used to. So, for example, the tenant's name, the tenant's current address, landlord details, landlord contact details, whether bills are included in the rent or not, the rent amount, frequency, and so on. Okay, so it's a very, very simple document, but it is a statutory requirement. And as I said, the written statement can be given to the tenant before the tenant signs the assured periodic tenancy, so that they're aware of what the terms of the contract are, or it can be combined as one document. Okay, so that's very, very important to bear in mind. As I said, this only applies to new tenancies. Okay, so the new tenancies that started from the 1st of May onwards. Now, just as an aside to this, if you ever come across a situation where there was no written contract and the tenancy began before the 1st of May, then you would issue a written statement where there was just a verbal contract. Okay, so that's quite important to bear in mind. So the written statement is something that everybody's become very familiar with, I would say probably since the middle of March, and very aware of that forms part of the new norm about what we need to do to inform the tenant of the terms of their tenancy. Now, the information sheet. Again, brand new, but something that we've never had before. I just want to stress that this information sheet does not replace the How to Rent guide. Okay, so there is no How to Rent guide. We don't issue the How to Rent guide anymore. It was, disposed of, so it's no longer relevant. But this information sheet is a document that the government issued, and I think, again, on one of the sessions that we ran with DPS, we talked about the information sheet. I've given you a graphic, which is the front page of that document. It's a 4-page document, not very long, very simple, and it tells the tenant, and these are tenants that entered into a contract before the 1st of May 2026, what the nature of the new contract is. And like I said, it's very, very brief. It's not in depth, very straightforward, easy to understand. And those key points are actually on the screen. Now, with this document is time sensitive. What landlords should have done is to have issued this document to all named tenants on a tenancy that began before the 1st of May by the 31st of May 2026. So there was a very distinct cutoff. Okay, so very, very important that you kind of remind yourself, do you have the evidence that this document was served? Can you prove how it was served? Can you prove that it was served by, and I'm not going to say end of business on the 31st of May, because the 31st of May was in fact a Sunday, but can you prove that that document has been served? So that's really, really important. As I said, this document will only be served once. This is not an ongoing situation. So the written statement is all new tenancies that began on or after the 1st of May. And this document takes you up to the 31st of May. We draw a line in the sand and then we stop. Okay, so very, very important that you're aware of those two things. Crucial new legal duties. One will continue, and this one has effectively an end date to it. So this is our first poll question. And this is not to confuse you, I'm just very curious as to what you might be thinking. And the question is, can the information sheet be served after the 31st of May 2026? Yes or no? So I'm going to go a little bit quiet while people decide, what they feel. I'm going to put my answer in. I'm not. Oh, so we've got A at 22% and no at 76%. Well, the correct answer is in fact yes. Now, I don't want to confuse you here. The reason why it can and there's a caveat to this, is if you've been keeping an eye on the government website, the government issued some new guidance about 2 weeks ago about the information sheet. And the only reason legally where you would be able to serve the information sheet is if you'd served a Section 21 before the 1st of May 2026. Now, if the landlord intends to action that notice and it goes to court proceedings for possession, then everything stays as it is. But if the landlord decides not to pursue the situation, not the matter through court, or the tenant's going to stay, then the landlord needs to serve the information sheet. So it's a bit of a trick question, effectively. The other reason where I would say yes would legally be a problem if it had nothing to do with Section 21 or court claims, and let's say that I, as the landlord, had forgotten to serve the information sheet, then that would cause me a problem. Okay, so I can see why the majority of you went with no, which is great legally, but obviously if it relates to Section 21, then potentially you would have to serve the information sheet. Okay, so increasing rent and the new mechanism. I would say that this is one of the pressing topics. Now, what we'll do for attendees on this webinar this afternoon is send you some information that comes direct from our blog. The information is important because what it does is show you what's been going on in the last 6 weeks. Topics that I wouldn't say have become trends, but that are quite key, and this is one of them. So this is the rent increase mechanism, and the mechanism effectively, again, we've talked about this before, is via Section 13. What I want you to be aware of is that Section 13, Form 4A, and you can find this on the .gov.uk website, is the only method that landlords can use to increase rent. Okay, so this is really, really important. It doesn't have to be a time-sensitive document, but what we try to do is make sure that this document is served in line with the anniversary date of the tenancy. And by anniversary date, I mean the date that the tenancy originally started, because remember, we're no longer interested in, well, I say that in a not flippant way, but we're not really interested in the end date anymore. And renewals, we're interested in the start date and the rent due date, so that we can work on an anniversary date and make sure that the notice hits in line with that anniversary. So that means landlords can increase rent annually. They can plan forward to make sure that they hit that date and they're not late in having that rent increase in place. And also, one of the key things is that landlords need to make sure that they are increasing rent in line with market rent. Okay, now this is one of the trends that we've been seeing probably since before Christmas, where letting agents predominantly have been looking at how they're going to navigate this for their clients. Okay, so rather than have a renewal process, the majority of letting agents have what is called a rent review process. Now, I'm going to be very open about this. I personally think that, having seen for the last however many years, 20 plus years, that renewals are done in a certain way, this actually is much more involved. It takes a lot more work. Some people have said to me, it's not complicated, you're just filling in a form, but there's a lot of prep that goes into this prior to filling in the form. Obviously, the notice will have the tenant's name and address, which is clearly the property address, but also very much dependent on who's serving the notice. It's either going to be landlord contact details and address, or letting agent contact details and address. So as I said, this is much more involved. So I really want you to think about this very carefully. If you are a DIY landlord, if you don't use a letting agent, I would probably say that letting agents are more geared up to deal with this process. Why? Because this is, you know, their day job. This is what negotiators deal with every single day. So in terms of preparing for the rent increase, this needs to be prepared in advance. You need to be thinking at least minimum 3 months ahead, okay? Because the notice itself is a 2-month notice period. So you're going to add a few days for postage and service. So I would say 3 months and a week to get ready to make sure this hits on the date that is required. You're going to have supporting evidence, and you're going to have to adhere to statutory procedures. The statutory procedure, as I've said, is the Section 13. You may have had a chat before the 1st of May with the tenant. You may have agreed something via email or via WhatsApp or via text. That is no longer relevant. It's the Section 13 that has to be translated from what you agreed into a statutory form. You need comparables. Why do you need comparables? I'll talk to you about that in a second. But what you should be looking at is 3 to 5, no less than 3, similar properties with similar amenities in the same area. They may be listed on property portals, they may be let privately, but you're looking for real-time specific market data. Okay, so this is why I say this is much more involved than not that just doing a renewal was easy, but this is much, much more detailed. You should be using strong resources, and there are a huge amount of resources available, definitely to letting agents. They know where to find them because they use them every day. And that obviously for a landlord is a benefit because that information is in real time. And as I said, it's in-depth market data. What you should also be looking at is supply and demand. At the moment, I had a discussion with an agent this morning and they said demand is very high and supply is really low. Okay, that lots of different reasons behind that. One of them you could possibly say is the Renters' Rights Act. You know, part of some landlords and landlords decided to sell really not knowing what this was going to bring. Obviously, you need to take into consideration what the property has achieved, what it's currently being let at, and what the market rent is. Okay, the point here is not percentages, CPI or RPI. Okay, we're not interested in that part. We're interested in market rent currently. You then collate the data, and I would most definitely say that, and this is what our clients do, have a chat with the tenant before you serve a Section 13. Now, I've heard people say to me, no, you shouldn't do that. It's illegal. It really isn't. Negotiation has never been illegal. So you can have a chat. You can see how the land lies. You know your tenants better than I would. Your letting agents know your tenants really well. They know if there's going to be any resistance. So even before you serve the Section 13, you can kind of get a general idea of how this is going to go. Okay, and that is really, really important because obviously you have the data. Obviously, the tenants can challenge the rent increase. So once you've served your Section 13, you don't need to do anything else. And again, this is a bit strange because we're discussing this now, but a person asked me this morning, once I've served the Section 13, do I need to have a discussion with the tenant and advise them how to challenge a rent increase? The answer to that question is no, you don't have a duty to do that. Everything is on the Section 13. It's got notes. Tenants should be reading. It's entirely up to them, and it will tell them what they need to do if they want to challenge. So I'm telling you what you can do, what your tenants could do, and that is complete a Form 6. The Form 6 is online. I've tested it and trialled it myself. That form goes through to the first tier tribunal, property chamber. The tenant has to pay £47. That came out of the woodwork, out of nowhere. It's very bizarre. But the surprising thing, if you go onto the Form 6, is the tenant has to fill in a huge amount of information. Okay, now you might think, well, it's £47. Okay, this might go in the tenant's favour. They've got nothing to lose. But they have to pull together all the tenancy agreements, property inspections, comparables, maintenance history, everything to do with that property. Floor plan, believe it or not. They shouldn't be going to an agent to ask them for that information, by the way, because the likelihood is they've had most of it, but it's not up to a letting agent to provide them with information so that they can then challenge a rent increase. So how agents and landlords navigate that is up to them. The tenant must also provide reasons. Now, affordability is not one of them. Okay, lack of affordability, saying, you know, my circumstances have changed. What the first tier tribunal will be looking at is they'll be looking at, is this a market rent? Is it reasonable? Okay, so that is very, very, very important. So this is why on the previous slide, I've given you an overview of what you need to be doing to get ready just in case the tenant takes this rent increase to the first tier tribunal. Okay, so you want to be very belts and braces about this. Pull all your evidence, because the first tier tribunal will be looking at exactly the same information. Now, the FTT will then notify landlord or agent or both, depending on who has served the Section 13, and invite those parties to a hearing. Okay, and the hearing could be face-to-face, a paper hearing where they don't discuss anything with anyone, they just look at the documents, video or telephone, okay? And the decision will be made by the first tier tribunal. Now, that is known as determination, okay? And the first tier tribunal will determine whether the increase, and let's use £100, is reasonable or not, okay? If it is, that's all good, that's fine. And if it isn't, the landlord may not be terribly happy, but both parties have the opportunity to appeal. Now, it's not the process that's the problem, it's the time it takes. And this is why I think you need to have discussions with your tenants and see whether it is worthwhile that you go to tribunal or not. It's entirely up to you. The reason for that is that there's a backlog. It may take 6 months for the first tier tribunal to make a decision. And within that 6 months, if they do decide that your rent increase is perfectly fine, okay, they agree with you, then that increase will not be backdated. So if it took 6 months and the rent increase is £100, so that's £600 the landlord wouldn't be getting, okay? And from the point that that agreement is made, the landlord then has to wait a further 12 months to increase again, okay? So this is something that personally, if it was over £10 and the tenant was challenging, I really wouldn't bother going to first tier tribunal. That's not up to me, obviously. But I think, you know, we choose the battles that we think we want to take on. So I think that that is extremely important to think about. So the key takeaways here, to make sure that you prep in advance, to look at what the market is doing, to pull together a lot of evidence. Because remember, the tenant is going to be looking at exactly the same evidence, if they can be bothered, as you are. Okay, so that's, you know, that's absolutely fine. And then obviously it's the tenant who has a 2-month window to challenge that rent increase. Okay, so they need to do that, to put that into play before the rent increase takes effect. So we have another poll here. Poll question actually is linked to what we've just talked about. Landlords can rely, and this is more a statement, it's more of a true or false, but I've called it a yes or no. Landlords can rely on a rent increase clause in the original AST, yes or no? And by original, I mean before the 1st of May. Very good, very good. So yeah, this is not a trick question. So we've been asked this quite a lot since the 1st of May. I don't know, 2-year contract that was a 2-year contract with a percentage for a rent increase at what would have been the beginning of year 2 of, let's say, 15%, which is quite a lot. Can we rely on that? No. Okay, so that's, yeah, very good. You all know what you're doing, which is great. So again, I've picked some topics for this session where we're seeing a lot of information, a lot of questions, and a lot of activity. And there's a huge amount of activity, which really, really surprised me, to be honest, around Section 8. Now, before I look at the elements that have been coming up over and over and over, I want to think about something that should be part of the day-to-day of running a letting agency or running a property portfolio. And that's making sure that everything is put in writing. Now, my focus here is not just breach of contract. It is overarching. Anything to do with the property, from the point that the offer is made by the tenant, the offer is accepted by the landlord, obviously your written statement, the terms of the contract, everything has to be put in writing. Okay, and what that tells us, not to say that this is common within the industry, but I think everything is becoming more formal. Okay, it's not just a handshake or a verbal agreement. It really, really is important to document every single element of that let. Two things that I really want you to think about: the history of maintenance and repair. That's something that we've been talking about a while. Well, personally, I've been talking about for the last 21 years. But we've got some new changes that come into play on the 23rd of June, which I'll mention right at the very end. And then any situation where something possibly goes wrong, it could be a breach, it could be that the tenant doesn't allow access, and you've got to document everything in writing. Now, why would you document everything in writing? Because you don't know where it's going to end up. And I was given a really good piece of advice many years ago by our barrister. And he said, prepare everything that you do as though you're going to end up in court. So that means document everything. So in this case, because we're talking about Section 8 and we're talking about the possibility of having to serve a Section 8 for breach of contract, even if you know that the tenant knows they're in breach, you need to put it in writing, okay? Don't think the tenant knows they're in arrears, so I'm not going to tell them. You need to tell the tenant that they are a week in arrears, a month in arrears, okay, that their rent has been paid short. You have to tell them, okay, because that then becomes evidence that shows that you, as the letting agent and or the landlord, are professional and you've told them what the situation is. Okay, so that's really important. In not doing so, it could go against you, okay, because when you start a court claim for possession under Section 8, a judge, the courts always want to know what you've done. How have you contacted them? Did you tell them they shouldn't have a dog? Did you tell them they shouldn't be running a business? Okay, so make sure that when you find out the information and you've investigated, you put it in writing. You tell the tenant formally, no emotion, and always refer back to the contract. Be consistent with your communication. Remember, this is about professionalism. You know, this is about making sure that the tenant is clear as to what they may have done wrong, okay? And then it also gives them an opportunity to remedy the breach, okay? Now, just on that point, guarantors. If the tenant has a guarantor, you send a copy of what you've sent to the tenant to the guarantor, always, okay? Because remember, the guarantor is underpinning the risk. So understanding the Section 8. Now, I've said this before, and I don't think many people will agree with me, but I'm a big fan of Section 8. So I have been for the last 20 years, never been a big fan of Section 21, found them too messy. So Section 8, what is it for? It's not an eviction notice. That should come as a surprise to everyone, because all I keep reading on government websites and guidance is that this document is actually an eviction notice, and it actually is not. It's way, way, way far removed from eviction. It basically is a mechanism that allows the landlord to seek possession, okay? But unlike the Section 21, the landlord needs to have a reason, okay? And those reasons are known as grounds. Okay, so there are new grounds, there are existing grounds, there are grounds that have been amended and updated, but in total, you could say there are about 30 plus, but actually under all the titles, there are 18 grounds for possession. What the landlord needs to do is they need to tell the tenant why they're serving notice. Okay, now if it's a breach of contract, what you do is you gently lead up to the Section 8, and your letters and your communication becomes more and more serious as you approach the Section 8. But if you intend on selling, that's not a breach of contract. And as long as you're working within the time frames of those grounds and the law, then you can tell the tenant via the Section 8 that you intend to sell, or you intend to move in to the property, or under Ground 6, you intend to redevelop or demolish the property. Okay, so you have to have a reason. This is your only framework, which is why keeping records is really important, okay, especially for breach of contract. Now, I've put this slide in so that when you revisit the recording, and most of you will be familiar with these links already, you'll know where to find the documents. The first link will tell you where the templates are. And the templates that you are interested in as landlords and letting agents are Form 3A, which we're talking about now, and Form 4A. The Form 3A is the Section 8, and the Form 4A is the Section 13. Okay, so that's the first link. The second is the guidance. There's guidance for landlords, and there's guidance for tenants, which is a good thing. Okay, so that information is there. But it's the one right at the very bottom that I really want to draw your attention to. And the key word in there, or keywords, are legal wording. Okay, each ground has a set of wording. Okay, and it's been written obviously by lawyers for the government in relation to Section 8, and you have to use that specific wording. So, for example, Ground 6 for demolition and or refurbishment, but substantial refurbishment of a property, the wording goes on and on and on for pages. Okay, it's probably 3-4 pages long. Okay, and you have to take that and put it into the Section 8 notice. The wording for grounds 10 and 11, which form a part of the breaches in relation to rent, are quite short. Okay, so you need the specific wording. The wording has not been put together by organisations like ours, and it most definitely hasn't been put together by AI. Okay, so that is your point of reference. And if you intend to deal with this yourself, you need to be certain that these documents are completed correctly. So familiarise yourselves with that part of the government website. And I will stress it's very, very good. Now, seeking legal advice. Why would you seek legal advice? Because that's part of due diligence. Okay, if we're not certain, a lot of our clients have said they will not serve Section 8s for the next 12 months because they just want to see how the land lies in relation to possibly any case law that they're particularly interested in. But it's important that we all understand that this is a new document. The grounds, not all of them are new. The notice periods have been amended. Mistakes can be made. So if you are unsure, I will stress that unless you've obtained good legal advice, then don't serve these notices yourselves. Okay, so just be certain that because of lack of understanding, or you think, well, the arrears are so substantial, I don't know what to do now. You know, the tenant might dispute the claim and say, yes, I did pay rent, but you don't have evidence. You just need to be certain that you've got support. Now, it's bullet point 2 that's of interest. I am not an insurer and I cannot give advice on any financial product, and insurance is a financial product. So what I would say to you is speak to your insurers about how rent and legal protection in relation to buy-to-lets and so on is dealt with, okay, because they will guide you, and that is really, really important. And one of the key questions to ask is in relation to the service of the Section 8. What will they do for you? Okay, so please bear that in mind. So one of the things that solicitors will do, legal firms will do, insurers will do, is before a notice is served, they'll identify lots of different elements. And I've split this into 2. The first thing is, are you actually using the correct ground? Okay, I'm fortunate enough, I don't know if it's fortunate or a little bit strange, to know the grounds off by heart. And that's because I've been dealing with them for such a long time. So I would know which ground I need to rely on, or if I can mix the grounds, or if I can add grounds. So that's really important. You need to identify the correct ground. You need to check that you've got an assured periodic tenancy, because obviously from the 1st of May, all pre-existing tenancies, regardless of when they started, but most definitely if they started before 96 or before 88, will have become an assured periodic tenancy. So that's a given. We don't use these for company lets, licenses, common law agreements. Ensure the ground relied upon is available to you. So if the tenant is 3 monthly payments in arrears, okay, that's 3 monthly payments under the Renters' Rights Act, I can use ground 8. But if they're 2 monthly payments in arrears, I can't. Okay, I can use 10 and 11, but I just need to make sure that I can use the particular ground that I want to rely on. And then I need to check the notice period, and the notice period is important. You've got a range of notice periods. You've got immediate, which is for ground 7 and 14. Then you've got 2 weeks, 2 months. I should have put in between those 4 weeks, and then 4 months. Okay, and basically what that tells the tenant on the Section 8, if you haven't vacated in 4 months' time and a couple of days, then I'm going to start court proceedings. That's what it's for. Okay, so we're giving the tenant an indication of what we're going to do within a certain time frame. Now, the compliance element. alongside the grounds, unlike the Section 21, where we had the Deregulation Act and lots of paperwork that we needed to check had been served, okay, before the tenant moved in. Here, the point of reference is the deposit. Now, in the future, when we have a database, this will all become easier. But at the moment, what you're going to have to check is the deposit was properly protected within the set time frame, prescribed information was given, terms and conditions for the relevant scheme, and obviously we're on the DPS webinar, so whether it's insurance-based or custodial, you need to make sure you serve the correct terms. Rent arrears calculations are correct at the time of service. Okay, so I mentioned 3 monthly payments. It needs to be 3 monthly payments at the point of serving the notice and at the point of the court hearing. Restrictions, are there any restrictions against service? So I cited grounds 1 and 1A and ground 8 as well. And then something that has kind of slipped under the radar, and this is known as prior notice. Now, some of the grounds require prior notice for landlords to be able to rely on them. Okay, now, fortunately, it doesn't apply to 1, 1A, 8, 10, 11. Okay, but it does apply to the series of grounds 2, 5. I'll do that again because it doesn't go in numerical order. 2, 4, 5, 6, and 18. Okay, and that prior notice could be that the grounds appear in the contract, so the tenant has been told the landlord may rely on those grounds. Okay, so that's important to look out for, because if you haven't used your prior notice, then that is going to be a problem. Okay, so grounds 1 and 1A, I would say from the 1st of May and even before the 1st of May, most of the questions around Section 8 have been in relation to these two grounds. And as I said at the beginning of this part of the webinar, I was really surprised that landlords hadn't served a Section 21, or perhaps they couldn't have done because they didn't have a break clause and the tenancy had just started and they were waiting for the Renters' Rights Act. So remember, these are two significant grounds. It says added, but that should be obviously amended and added. Ground 1 was in existence before, and that used to be a prior notice ground, and now you don't have to serve that notice in advance. That ground rather in advance to be able to use it. So we've got ground 1 that allows a landlord and or a family member to move back into the property, and then ground 1A if the landlord intends to sell, and we've seen a lot of these being served. Now, a couple of things that you need to be aware of, which I know that you probably are, but we're just going to revisit them. These are the restrictions, and we'll get to a point where tenancies that began before the 1st of May 2026, there won't be any restriction. The landlord, when they're ready, can serve Section 8 under ground 1 and ground 1A, and they'll serve their 4 months notice plus a couple of days, okay, because the tenant has been living at the property for 12 months or more, okay? But it's the new tenancies where the restrictions kick in, okay? And people have said to me, why? It's not fair. Why would the government do this? If you look at what the Welsh government have done with Section 21, this is no different, except we're just using a Section 8. What the Welsh government have done is that they have a minimum term of 6 months and then a notice period under Section 21 of 6 months. And there's your 12-month period. This is no different. Okay, basically what it's saying is that the tenant should be entitled, rightly, I believe, to their first 12 months of a tenancy, okay, without being disturbed, unless they want to leave. Okay, so that means that you can't have a Section 8 under Ground 1 and Ground 1A that expires in the first 12 months of a tenancy. And I mean new tenancy, not a pre-existing one. Okay, so that is really, really important. The other thing that's really important, and I've got a poll for this, and it will be interesting to see what the answers are. And I know it's a little bit of a tongue-in-cheek poll, but the restrictions, if a property doesn't sell, or if the landlord doesn't move in, is that they've been put in place because the government believe that it's these two grounds that will be misused by landlords. Okay, you might think, why? Because the landlord might think, well, I'm not genuinely selling, so I'm just going to say I'm selling, put my property up for sale, the tenant vacates, and then I'll relet. And the same applies with the landlord who had no real intention of moving into the property. Okay, so that is why the restrictions have put in place. Now, in an environment where you have agents who negotiate on your behalf, it could be that you can avoid serving a Section 8. Okay, and then that makes the poll that I'm about to put on screen a little bit more interesting. But the restrictions only apply for relet and remarketing if a Section 8 has been served and has expired. Okay, so that's really important to bear in mind. Now, one of the things that I would never do is to tell landlords or agents to break the law, because the penalties for serving a Section 8 under Ground 1 and Ground 1A, where the reasons aren't genuine, you're looking at up to £40,000 fine. Okay, so, you know, whilst we think that the restrictions are ridiculous, I can understand to an extent why the government decided that there needed to be a restriction. Under the previous government, it would have been less of a restriction, 3 or 6 months, not 12. But, you know, we need to think about people that quite happily break the law. So the question is based on Section 8, Ground 1, Ground 1A. Ground 1A has been served. The tenant vacates 4 months later and a few days on the 8th of October. So, you know, we're in the future. The sale falls apart. So the tenant's gone, landlord approaches their letting agent to relet. And what should the response to the letting agent be? Is it A, yes, I'll relet for you if you make it worth my while? Or B, no, the property can be remarketed, re-advertised and relet 12 months from the date of expiry of the Section 8 notice, which would be, believe it or not, 8th of October 2027. So I can't see my answers. I think I have answered, but I can't see. Yeah, everybody's gone. 99%. Yeah. And listen, I know it's challenging and you might think it's unworkable, but like I said, we've seen a lot of Section 8s. I can't tell you exact numbers. That would be probably good for the next webinar to see how many Section 8s have been served under these two particular grounds and whether landlords have, you know, experienced any resistance or not. But to be honest, I don't personally see much of a problem. I think if a tenant feels that they want to leave because the landlord is selling, then it's a discussion that can be had in advance before the Section 8 is served. Okay, so that point B is really important. It's not just marketing, advertising, reletting. That restriction is in place for all those three things. Okay, so that's very, very important. Okay, so grounds 10, 8, 10 and 11. Now, I've put these in because these are the most commonly used grounds and I don't think anything's going to change. I would say that over the last 20 years, pretty much every single Section 8 I've dealt with has been rent arrears. The ground 8 is the mandatory ground, and the grounds 10 and 11 are the discretionary grounds. But what I would tell anybody dealing with this is the minute that the tenant is in arrears, and I'm not talking about a day or 2 days, but as it moves towards 7 days, 14 days, you've got to start putting things in writing. And I've given you some information on that. I know for a fact that letting agents have very, very sophisticated systems in place to deal with this kind of thing. Okay. And that's what you need to be doing. Okay. And the more, the higher the rent arrears, the stronger the letters get. Okay, so they could start off gentle, but by the time you get to stage 4, as I've put on screen, it becomes more and more serious. And you tell the tenant, you know, in a very professional way, what could happen, not what will happen, but what could happen if they don't remedy the breach. Now, if you decide that you're going to enter into a payment plan, if this is a discussion that letting agents have had with their landlords, great, but you need to nip this in the bud, okay? Because you cannot leave this 3, 4, 5, 6 months, okay? It's really, really important to act on this quickly. Remember what I said, if there's a guarantor, then you make sure that the guarantor receives a copy of all those letters, because the guarantors won't be happy, especially the guarantors that are homeowners, okay? Because that will impact them heavily if the landlord decides to get, you know, a charging order against their property. So mandatory ground 8 is one of my favorites. If you go to court on this, you need to be 3 monthly payments in arrears at the point the Section 8 is served. So it can't be £1 under, which I tell you is a trick that, you know, previously when it was 2 months, and I'm sure when it goes, you know, moving forward to 3, that tenants will figure it out. I wouldn't be able to use my mandatory ground 8 if it's £1 short. At the time of the court hearing, again, you've got a statement of account and you can move quite quickly on this. We need to give the tenant 4 weeks notice as opposed to 2. So by the time the Section 8 has expired, the tenant will be 4 monthly payments in arrears. And that's when you need to make a really quick decision, okay? You need to have spoken to your insurers. You need to look at your rent and legal protection. You need to make sure that this is dealt with professionally and effectively and efficiently, okay? Because that is really, really important. If the tenant on the day of the court hearing or before pays the rent up in full or part payment, then that ground 8 will fail. Okay, because the judge must give possession. So that's why when we serve the Section 8 under ground 8, we also use 10 and 11. And I love 10 and 11, okay, because they're really handy to have in your back pocket, because even on the day of the court hearing, you can say to the judge, look, you can see by the statement of account that the tenant has been paying just under £1 to keep this under the mandatory ground 8. Okay, and that's what the judge is looking for. The judge is looking for evidence. So I've given you some quite in-depth information to use. You could go to court on a discretionary ground, but you need a lot of evidence. Okay, so the evidence for me would be that every single month the tenant knows their 2 monthly payments and just under 3 in arrears, and they just keep playing that game. That's my evidence, okay? But I need to be really certain that that's what I'm going to do. Now, procedural errors, and you know, I'm happy to say, and I don't mean happy in it's Christmas or it's my birthday kind of way, confident enough to say that I've made a mistake on a Section 8 in the past, and it's not a mistake I'll ever make again. Fortunately, my client was very understanding, and so was the judge. So yeah, I was very lucky that day, but lots of errors. And this doesn't just apply to notices. It applies to paperwork, tenancy agreements, Section 13. Just cross-reference everything, okay? If you're unsure about somebody's Christian name or surname and it looks different as to what they gave you, double check everything. It's really, really important. And again, no disrespect to landlords, but letting agents are good at this. They cross-reference before they serve. And that's what your insurers will do. And that's what your solicitors will do. They will not go to court on a defective notice. They would rather you reserve. They won't go to court for you on a Section 8 where the deposit was not protected. Okay, so you need your evidence, which I call belts and braces, or you can't see the ducks behind me, but making sure that you get all your ducks in a row. Okay, so this is really useful for you just to think about, because everybody makes mistakes. Everybody's human. We just need to be sure that we cover everything off. So, service of notice by a tenant. So I've given you a poll question here. And this is quite interesting. If one tenant in a joint tenancy, so let's imagine we've got 4 tenants, joint and several on the same contract, and one of them serves notice, it will bring the tenancy to an end for all tenants. Again, yes or no, but that should really be true or false. So I'll let you decide what your answer. Very, very good. Very good. So 75% of you have said that it will. And before I look at notice periods for tenants, this is fact. It's caused a lot of problems since the 1st of May because from the 1st of May, a lot of joint tenants have been serving notice. So you need to look at what your options are. But the first thing that you should do if you have a joint and several tenancy, and as I said, it could be 4 tenants, it could be partners, it could be husband and wife, it could be boyfriend, girlfriend, it could be whoever, but they're joint and severally bound, and one of them serves notice, it has to be 2 months. It has to be a 2-month notice period. If it's a joint and several agreement, then what you need to do, even if you're not sure if the other tenants are aware that notice has been served, is you write to all of them and you confirm receipt of notice. And then you say to them, whatever you're going to say, you'll say to them, dear tenants, thank you for receipt of notice. The tenancy will come to an end on this day. Okay, and we'll contact you I don't know, before the end date to deal with the checkout and things like that. So it's important to understand what you're going to do next. Now, there are 3 options. 3, there's my 3. Option 1 is all the tenants leave. Okay, which sounds a bit harsh, but that's what the law says. Okay, unless the landlord decides otherwise. Option 2 is the remaining tenants stay, okay, as they are. Okay, so that is up to the landlord. And that is really, really important because this is not a decision that can be made by the letting agent or by the tenants. Okay, so you have a chat with the tenants that are not leaving and you say, can you afford this? Are you going to bring another person in? And so on and so on. So you can leave the contract as it is, but you can surrender one of those people. The third option is that if those 3 remaining are staying and they can afford the rent, the landlord can decide that they want a brand new contract. Okay, so it'll be a brand new assured periodic tenancy. Now, the downside with that is that the restrictions under Grounds 1 and Ground 1A will start again. Okay, so that's something for landlords to bear in mind. But they're the 3 options for landlords. And I think that that is really, really important to bear in mind because you need to think, do I want to keep these tenants or don't I? What's going to happen? Can they afford to stay? Can they not? Okay, so that is something that needs to be thought of when the tenant serves notice. And that is really, really important. Now, tenants just serving notice. We know that we've gone from 1 month's notice to 2. But there is something that I'm going to send DPS that I've been looking at today and probably for the last 3 weeks, and this keeps coming up. Some tenants are saying to landlords and agents, I don't need to serve 2 months' notice. My original contract says that when the tenancy becomes periodic, I only have to serve 1 month's notice. Now, we're getting a lot of questions on this, and this is my example of one of the trends. And it's actually not a trend, it's a statutory thing. Basically, that's correct. If the previous contract that they had, okay, so it went from an assured short hold tenancy to an assured periodic, but in that assured short hold tenancy, it stated that when the tenancy becomes periodic, the tenant serves 1 month's notice. That's actually correct. Okay, so you need to really be vigilant on this one, because some tenants are aware, other tenants are not, some agents are aware, most landlords aren't aware, and that's a really, really important point. Why is it important? Because if the landlord challenges this and then wants to deduct a further month's rent from the deposit, they could face a problem, okay? So it's only if the original contract, not a new contract now, but an original contract pre the 1st of May stipulated 1 month's notice for a periodic tenancy, then you need to consider that. Okay, so that's really, really important. So as you can see, lots going on. Now, I think we are close to the Q&A. I'm just looking at my timings. Yes, I am. So I think David is going to join us for the Q&A.
I am indeed. Thank you so much, Susie. That was incredibly useful and insightful as always. And I know one of your favourite phrases, getting your ducks in a row. It's always handy to have that lovely recap and go, what, have I got my ducks in a row? So yeah, ever so helpful as always. As you rightly said, we asked people to submit their questions ahead of this webinar, so we have this Q&A element at the end. There were a shed load of questions sent in, but what we've done is sort of picked out those common themes that we can have a look at today. So I'll read these out to you, Susie, and you can answer those. So the first question I've got here is, what to do if an information sheet has not been produced?
I think by produced, that means served. They could serve it. I mentioned this right at the very beginning. We had a time frame, which was the 31st of May. And only if you've served the Section 21 that you're not going to rely on, have you got additional time to serve. So as with prescribed information which has been served late, we don't have anything to measure this against. So the simplest thing would be to go ahead and serve it. But obviously, you've got to remember that the tenant could challenge and say, well, I'm going to report you to local authority because you didn't issue this by the 1st of May.
And I guess it's one of those things, isn't it, where it's sort of tenant-led in scenarios like this when something hasn't been served. It's the tenant will then take that action. Fantastic. With this question, the person's asked for 3, but I'll ask it more generally. What do you think are the biggest compliance risks under the Renters' Rights Act in the first 12 months?
Yeah, I really like that question a lot. I suppose I could come up with 12, but we'll stick with 3. I think where Section 8 is concerned, always go back to the deposit. Okay, the deposit is so important. And again, it's really strange because the deposit, tenants deposit protection, as you and I and everybody online knows, has been around since 2007. So just do your compliance checks first. I would say the second thing is maintenance and repairs. We haven't done so yet, and I know that you and I are going to be discussing a few things maybe in the next few months or so. But the Housing Health and Safety Rating System, HHSRS, changes on the 23rd of June of this year. And that's something that is really important. So people need to be looking at how they deal with repairs, how they deal with maintenance, the response times, because following on from that, we're obviously going to have AWAB's law. And I think that one of the things that landlords have been concerned about, most definitely on the private rented side. So that's the second thing. The third thing is to make sure that landlords, and I say this with the greatest of respect, get their sources of information from legitimate sources. Now, I've given 3 links to 3 bits of information that I use. I won't be going on to a forum. I won't be looking at AI. I won't be going anywhere other than the .gov.uk website. One of the things I know that we're not supposed to say, I'm impressed with what the government have said. Please don't hate me. But what I am impressed with, even though people feel, they've got opinions about the Renters' Rights Act, the amount of information that is available on the government website, use it. Please do not go down the AI route for wording, for documents. The guidance is there, the support is there, and that is because obviously, we're only 6 weeks in, and they would be my 3 key things to think about.
Great. The top tips there.
Yeah.
A question here: do you need to serve the information sheet for new tenancies that started after the 1st of May?
Well, I could have said no, but I'm going to say yes and no, just to reiterate the poll question. No, if it's just a brand new tenancy. And then yes, if you'd have served a section 21 and then you decide not to rely on it. Okay, so pre-existing tenancies where you've served a section 21 and you're not going to use that section 21, then serve the information sheet. Brand new tenancies, no, not needed.
Brilliant. And I think another question that you have already sort of covered off in the session, but do we need to give new tenants any information like the how to rent guide previously?
I want to say hooray, no. I was never a big fan of the how to rent guide, mainly because nobody ever read it, apart from, people like us and everybody online. And we did it caused us a lot of stress. No, this again was something that was kind of under the radar and a lot of people didn't think about because Section 21 is no longer there. The how to rent guide was linked to Section 21. So that's why there's no how to rent guide. So no.
Got it. Brilliant. How to sell if a buyer doesn't want sitting tenants?
So this is, again, something that's been discussed at length, I would say, since the Conservatives decided that there was going to be a restriction and there was going to be a ground for selling. So your options are that before you serve your Section 8 Underground 1A, is you have a discussion with the tenant. If the tenant wants to serve notice, that's entirely up to them. That's not a problem. But if the tenant doesn't want to vacate, and more so if the tenant wants to be rehoused, then you're going to have to serve Section 8 Underground 1A. And that's something, again, that people haven't really discussed. So that's a really good question, because the tenant might not want to stay. The buyer doesn't want the tenant there. Some buyers do, some investors, have a little bit of information without breaching GDPR about the tenant and think, yeah, this is good, I want to keep that tenant. But obviously it might even be the lenders that don't want the tenant there. So it would be either having a discussion with the tenant and or you serve your Section 8 Underground 1A.
Brilliant. We've got a question around joint tenancies, but I think you've covered that a couple of slides ago in terms of what we can do with that. So I'll just skip past that one. You've touched on, we're going to hopefully, as ever, do more with you guys at Guilds of Letting and Management. You're always so insightful. But there is a question about any clarity on when the remaining aspects of the Act will come into force, so the landlord register, etc.
Yeah, again, that's these are very important questions, because we've done a lot of planning, all of us, everybody online. I know DPS has, I know we have, lots of other organisations. So this is phase one. I've mentioned the Housing Health and Safety Rating System because, again, I think that's kind of, because of the Renters' Rights Act, that's kind of been a little bit ignored. But that's in preparation for AWAB's law. So on the 23rd of June, the Housing Health and Safety Rating System changes. I wrote a blog the day before yesterday. It's really boring, but it's good.
Everybody go and read it. Go and read it.
It's not fun, but it's insightful. And then I would say AWAB's law. There's going to be a consultation. AWAB's law has been up and running in social housing, and I've seen it working since the 27th of October 2025. So that's quite important. So you can have a look at what local authorities and social housing providers are doing on that side. And it's the response times that's really important. Response times, keeping records, documenting everything, and getting yourself ready for that. So I think maybe October 2026, possibly. And then the database, that's the big one. I would say that's the biggest piece of work. It's been a lot for letting agents and landlords to navigate phase one because it's been very paperwork driven. But I think that the database coming online, which I've been told will be piloted first, possibly this side of 2026, around autumn, and then rolled out to the rest of the country into 2027. So the advice that I would give there is that landlords and letting agents start auditing, and I think they have, their portfolios, making sure that all those ducks are in a row, that all the paperwork's there are no gaps in their systems, and landlords and agents working very closely together. Because I think, I can't confirm this, but I think agents will be able to do the work on behalf of landlords. But remember, it's a lot of work. It's not a little bit of work. So that will be into 2027. And then 2028, the landlord ombudsman. And then 2035, decent home standard. So a bit of time for that one.
Just a little bit. We'll blink and it'll be here.
Yeah.
A question we've got. So if there are received unexpected payments we sort of payments up front, we would commonly see historically, maybe overseas students, parents, people who are used to paying that 6 months, 12 months up front. What would your guidance be for people who unexpectedly receive that? So an agent or a landlord unexpectedly got the 6 months all in one go. So
I had a feeling we'd get questions around this, and this is something that has actually that we've been dealing with pretty much every day since the 1st of May, to my surprise, actually. So let's say that the parents accidentally pay the money in advance before the contract has been signed by landlord and tenant. All of it except a month, all of it would have to go back. Once the contract has been signed, the tenant can then pay 1 month. Okay, so that's really important. It's only a monthly payment that can be received once the contracts have been signed. Now, the surprising thing, not just me, because people said before the 1st of May, and by people, it could be anybody, what tenant is ever going to offer to pay rent in advance? I cannot tell you how many have. And when people are seeking advice, what I ask for is show me the evidence the tenant offered. So if the tenant has put in writing, it suits me, my parents want to pay the rent in advance, you need to make sure that that is documented in writing. There's no coercion, there's no discussion from the agent, from the landlord. This is a decision that is made solely by the tenant. Once the tenant has moved in, then they can make their additional payments. And it is really clear in the legislation. So, yeah. So be really mindful. Even if they pay £1 over a month's rent, then that £1 needs to go back.
Needs to go back and be returned.
Yeah. Yeah.
Brilliant. Well, I'm just conscious of time, but from our perspective, I know that I find this super useful, and the feedback I've had, not just today, Susie, the series of webinars we've done has been great in sort of keeping people up to date with changes as they happen, internal processes, landlords looking at what they need to do day in, day out. It's been super, super helpful. So again, thank you so much for joining us again today.
You're welcome.
These sessions are available to watch. So I've mentioned this a few times now. Feel free to share a like once we finish today's session. This is a guest webinar, so just to reiterate, all the content and information discussed by the lovely Susie from the Guild of Letting and Management. So if you have any queries about it, get in touch with the Guild of Letting and Management via guildofletting.com, and the email address and phone number on screen. If you've got any DPS questions, of course, visit the DPS website, depositprotection.com. And if you want to look at the government guidance that's supplied, you've got the website there for the government. So all that's left for me to do is say thank you so much again, Susie. Really grateful for you doing it, and lovely to see you.
Lovely to see you too. You're welcome. I hope it was useful.
It really was. It really, really was. And other than that, leave everybody to enjoy the rest of their evening. Thank you so much for joining. Take care.
Thank you. Thank you.